It is my respectful view, and only my view, that the monarch has the power to appoint a prime minister only once, and that too after elections. After that, any change depends on the decision of the legislature. I'll explain why. My name is GK Ganesan, and this is GK TV. Today's topic is, between elections, how many times can the monarch appoint a prime minister or a ruler of a state a chief minister? My answer is one, and there are several reasons for this. First, as I have argued before, the appointment of a prime minister requires several constitutional processes to take place. First, there must be a constitutionally valid election. After elections, the MPs are chosen. They sit in the Dewan Rakyat, or the House of Representatives. Before they first sit in Parliament, a majority of the MPs customarily exercise and express their support for one candidate and thereby select a prime minister candidate. The candidate then approaches the king, who, having granted an immediate audience, appoints such a candidate as prime minister. Next, the only time the king assumes the right to exercise his majesty's discretion is immediately after the general election. That is a logical and proper argument for several reasons. What if a PM dies or loses his command of the House of Representatives? Can another candidate approach the king and offer himself as a prime minister candidate? This is what has been plaguing Malaysia. This illness has recently afflicted the nation's prime ministers, who seem to have suddenly lost their parliamentary majority. Similar issues have befallen several federated states. This is because certain chief ministers have not been able to muster or maintain the confidence of the majority of the respective legislative assemblies. Such disputes have raged on for some decades. Several such ministers have filed cases in the courts. They have asked the courts whether a candidate vying for the post of a chief minister, but who's lost the support of a majority of the state legislative, could ask the hereditary ruler or a governor, as the case may be, to substitute one candidate for another favorite or current favorite candidate of the state legislature. The question is, does the Constitution allow for consecutive appointments? My view, mind you, and it's only my view, is that the Constitution does not allow for this kind of appointment. Why? We start with the principles of the rule of law and the separation of powers. The principles of the rule of law and the separation of powers, as promulgated and practiced by democratic countries all over the world, and as we now understand it, firmly place the right to rule upon the people. Since you and I make up the citizenry, and we do not have the means to meet all the time to discuss what is important for the nation and what laws to make for its benefit, we appoint our representatives who can do this on our behalf. Those representatives, you would agree, are the MPs who sit in the Dewan Rakyat, and therefore rules over the people. If the people need to choose a new leader, the duty and the right to do so falls to the people, and by extension to the Dewan Rakyat. Hence, the citizenry devolves and delegates and hands over its individual power to rule over to the House of Representatives. The MPs, or in the state legislative assemblies, as the case may be, when they meet, they will determine which leader has their confidence, and once they have made that decision, the king or the ruler of a state, as the case may be, merely rubber stamps their decision. That is the constitutional position. If the citizenry no longer has any confidence in any particular MP, then the electorate replaces them at the next elections. So who determines who is to be the leader? The only body that has the power to determine who should lead the people, either of the nation or of the state, is you and I, meaning the people. And only the people's representatives, the MPs, can determine that question. And that cannot be done at the palace, unfortunately, but at the House of Representatives or the state legislative assembly, as the case may be. The chief ministers of each state are chosen by the same mechanism. However, over the last 3 decades, several cases arose from disputes surrounding the appointment of chief ministers in Perak, Sabah, and Sarawak. This happened when MPs and state assemblymen abandoned their support for the incumbent chief minister and began to party hop. These cases, with all of which you are familiar, and if you're not, I'll list them here for you, gave rise to a set of principles which I'll now recite for you. These cases determine that, as a matter of principle, one, that the head of a state can refuse to dissolve the state legislative assembly when a chief minister loses the confidence of that assembly. Second, and alternatively, the head of state does have the discretion to dissolve the state legislative assembly, which will result naturally in elections. Three, the head of state can create a procedure by which His Majesty or the governor can determine for himself whether any particular candidate is likely to command the confidence of the majority of the members of the Legislative Assembly. And number four, the head of state can also demand the resignation of any chief minister whom he thinks has lost command of the Legislative Assembly. And finally, the head of state can choose to substitute one chief minister with another if that candidate can show that he is likely to command the confidence of the Legislative Assembly. Those are the principles that have been decided by the cases, which now brings us to the appointment of the Prime Minister at the national level. This discussion must commence with an understanding of how the Federal Constitution requires the King to appoint a Prime Minister. It is set out by the Constitution in Article 43, which I will now recite for your benefit. Clause 1 says, "The King shall appoint a cabinet of ministers to advise him in the exercise of his function." Clause 2 states the cabinet shall be appointed as follows. That is to say, paragraph A, the King shall first appoint as Prime Minister a member of the House of Representatives who in his judgment is likely to command the confidence of the majority of the members of that House, and he shall, on the advice of the Prime Minister is just appointed, appoint other ministers from among the members of either House, or the Dewan Rakyat or the Senate, as members of the Cabinet. Several state constitutions, except the peculiar one in the state of Sabah, have identical clauses for the appointment of a chief minister and the Executive Council. The relevant article in the state of Perak is Article 16, which states His Royal Highness shall appoint an Executive Council. The Executive Council shall be appointed as follows, that is to say, His Royal Highness shall first appoint as Menteri Besar a member of the Legislative Assembly who in his judgment is likely to command the confidence of the majority of the members of the Assembly, and paragraph B, he shall on the advice of the Menteri Besar appoint the members of the Executive Council, etc. Although the courts have impliedly construed these provisions in a particular way, I have a different view. I suggest that these judicial views do not pay sufficient heed to the historical development of constitutional principles or of parliamentary conventions or the underlying foundational theories of democracy, that leadership is the institution and choice of the people and not that of a monarch. Over the years, there has been a change in the rule of the monarch over hundreds of years. The UK 1689 Bill of Rights and the English 1700 Settlement Act, and which were afterwards promulgated as Parliamentary Acts, are accepted as being the foundation upon which the Malaysian Federal Constitution is based. We accept the legal principle that it is only the people who can rule and not the monarch. To the extent that the monarch has a place in the constitutional framework of both the United Kingdom and Malaysia, these are limited to those duties which the monarch carries out on the advice of the Prime Minister or that of the Chief Minister of any federated state. So, we now come to the cardinal principle behind this. The principle is the king doesn't rule. He cannot rule by proxy by choosing someone of his choice. Neither does a monarch have any say on which individual is to be elected as the leader of the people. If such a position is accepted as being the correct law, that flies in the face of 300 years of constitutional jurisprudence and the principles of the rule of law. To construe widely any constitutional provision granting powers or discretion to a monarch, and to disregard the role and function of legislative assemblies in a pedantic as opposed to a liberal, organic and flexible manner in keeping with the spirit of the law and its intent, and the right of the people to rule themselves and the right of the people to make any decision on which individual should be chosen as a leader is, in my view, the correct approach. We now come to the monarch's one-time exercise of power of appointment. I yearn for the days when our judiciary will recognize these principles, that the moment a ruler makes a decision in the choice of a chief minister, immediately after the election, any and all discretion that His Majesty enjoys in determining who is the chief minister after that are gone. Any process that determines the choice of who should be the next chief minister of a state or the prime minister of a nation, as the case may be, should be left in the hands of the representatives of the people. And the decision has to be taken in that assembly, not in a palace. Once the people have expressed their choice, then the king or ruler of the state or the governor must accept that decision. Although I am bound to obey and respect the laws as they are interpreted by the courts, I respectfully offer an alternative view for the consideration and discussion by jurists, constitutionalists, lawyers and politicians, so that we can return to the days when the rulers respected the choice of the people and refused to taint their hands with politics. My own view, based on what I've just argued before this, is that the monarch may appoint a PM or a chief minister, as the case may be, only once, and that too immediately after elections. When there is a vacancy in the office of the prime minister or that of a chief minister, as the case may be, then the right place to determine who should succeed the outgoing leader should be left entirely in the hands of the legislature of the people. The sight of several political leaders of differing parties rushing to the palace bearing a list of candidates, which list constantly changes with the shifting winds or the amphibian nature of the MPs who appear on it, is disturbing, unacceptable, and against accepted norms of constitutional law and convention. That is my view. Thank you for watching. If you like this video, please share this widely, press like, ring that bell, and if you haven't done that, please subscribe to this channel. Thank you very much, and until I see you again with another exciting video, goodbye.